Good evening, everyone. Thank you for joining us tonight. Welcome to Systems of Criminalization, a BCCLA panel presented by the Notary Foundation. My name is Jessica Magana, and I'm staff counsel in the litigation department of the BC Civil Liberties Association. It's my pleasure to moderate a panel this evening with BCCLA lawyers Maris Salanders, Megan McDermott, and Stephen Chin. Before we begin our event, I would like to acknowledge that the BCCLA is based on the stolen and unceded Coast Salish territory and the shared lands of the Musqueam, Squamish, and Tsleil-Waututh peoples. As we're all joining virtually, I recognize some members may be joining from many different territories. I invite you to take a moment to share which lands you are joining from in the chat now. In our acknowledgement of the lands which we occupy, we must also contend with the ways in which this violent process has a tangible human impact. Particularly in the work we do at the BCCLA, we must contend with the ways that a colonial legal system is used to oppress Indigenous people and Indigenous resistance. I encourage everyone joining us today to take a moment to consider the colonial structures in which they participate and how we can dismantle these systems. To make sure everyone can enjoy and fully participate in our event, I would like to go over some housekeeping for those who are joining us through the Zoom link. Please note that this event is being live streamed and will continue to be available through our YouTube. We've added the link in the chat for reference. We have ASL interpreters and captioning services joining us today. If you need to see the ASL interpreter and speaker at all times, please switch to speaker view by clicking on the button in the right-hand corner of your screen. Our ASL interpreter and speakers have been spotlit for convenience. For those of you in the Zoom room, you can also enable closed captioning by clicking on the CC button at the bottom of the screen. If you do not see the option for live transcript, you can select the More option on the far right of the taskbar, then select the Show Subtitles option. Please feel free to turn on your webcams if you are comfortable doing so. We just ask you not to make any inappropriate or distracting gestures while on camera. You can start and stop your video by clicking on the video camera icon in the taskbar. You will also be muted for the duration of the event, but you should be able to talk with everyone in the chat, both in the Zoom and YouTube live stream. In Zoom, you can see the chat box by clicking on the icon that looks like a little speech bubble on the taskbar at the bottom of your screen. You can use the chat to ask questions throughout the event. We have tried our best to have this event run smoothly and be as accessible as possible, but please forgive us if we run into any issues. We will try to resolve them as quickly as we can. And now that the housekeeping is out of the way, I will provide some brief opening remarks. For 60 years, the BCCLA has been fighting for equality, liberty, freedom, and justice. The BCCLA is the oldest and most active civil liberties and human rights group in Canada. Our work includes a range of civil liberties and human rights issues, such as police accountability, prisons and criminalization, Indigenous rights, national security and surveillance, migrant rights, privacy rights, patients' rights, freedom of expression, democratic rights, and equality rights. We accomplish our work through public education, law and policy reform, and litigation. We would like to welcome any members joining us from our annual general meeting held prior to this, as well as valued donors and supporters joining us by live stream tonight. Our work would truly not be possible without your support. If you are interested in becoming a member or donor, please visit our website at bccla.org. The topic of this evening's panel is systems of criminalization. Mara, Stephen, and Megan will examine the ways in which the criminal justice system imposes harsh and disproportionate impacts on marginalized communities. Throughout its history, the BCCLA has fought to address the unjust impacts of criminalization on marginalized people. We've been involved in constitutional challenges to laws criminalizing sex work. We've argued before courts that solitary confinement has unique and severe impacts on Indigenous people and people with disabilities. We've spoken out against the criminalization of HIV non-disclosure. Tonight, our panelists will speak to the BCCLA's ongoing efforts on 3 issues. First, the risks of criminalization faced by immigrants and refugees. Second, the continued illegal practice of street checks. And third, the efforts being made to decriminalize drugs. And with that, it is my pleasure to introduce the panelists. I'd like to first introduce our first speaker, Mara Salanders. Mara is a staff lawyer with the policy department at the BCCLA, and she will be speaking on crimmigration.
Good evening, everyone. Crimmigration refers to the criminalization of immigration law and the conflation of criminal and immigration legal schemes, where violations of the Immigration and Refugee Protection Act, or IRPA for short, attract criminal consequences, conviction of a range of crimes under our criminal code attract immigration-related consequences, and rights-abusing features of our carceral system are used in enforcing immigration laws. Crimmigration ignores the fundamental human rights of immigrants and refugee claimants in favor of a nationalist and border policing regime. Immigration law is administrative, and despite its conflation with criminal law, does not attract many of the constitutional protections that accompany criminal law. Immigration and deportation have evolved from administrative processes to become a criminalized process of warrants, arrests, detention, and deportation. Even the Canada Border Services Agency more closely resembles a police force than a government department. I will now provide a brief overview of the prime ways in which crimmigration doubly punishes immigrants and refugee claimants. First of all, a broad set of crimes attract immigration-related consequences. IRPA imposes immigration consequences with reference to criminal code consequences. So if a foreign national or permanent resident commits a crime with a certain type and length of sentence, for example, they would be deemed inadmissible and could be removed from Canada. The range of crimes that entail immigration consequences is incredibly broad, ranging from murder to petty theft and simple possession, for example. Inadmissibility is a legal concept that refers to all the ways by which CBSA can deny entry to or potentially remove a foreign national or permanent resident from Canada. A person may be deemed inadmissible for a range of reasons. Those associated with crime, generally, though not exclusively, fall into 3 categories under IRPA: serious criminality, ordinary criminality, and organized criminality. Each of these inadmissibility categories attaches immigration consequences depending on the punishment for the crime. For example, the IRPA section on serious criminality states that a permanent resident or foreign national is inadmissible on the grounds of serious criminality for being convicted of an offense punishable by a maximum term of at least 10 years, or of an offense for which a prison term of more than 6 months is actually imposed. So the idea here is that by considering the offense in terms of its sentence, the provision appropriately captures serious criminals who do not deserve to remain in Canada. For ordinary criminality, the IRPA section states that a foreign national is inadmissible on the grounds of ordinary criminality for having been convicted in Canada of an offense under an act of parliament punishable by way of indictment, or of two offenses under any act of parliament not arising out of a single occurrence. So if the offense is a hybrid offense, meaning it could be prosecuted by indictment or summarily, under IRPA, it is automatically considered an indictable offense, regardless of whether the Crown elects to proceed summarily. The Crown may make this election in instances where the offense is less serious, and we see that often. This decision is at their discretion. Foreign nationals in Canada, however, do not get the benefit of this discretion. And some examples of hybrid offenses include things like impaired driving, again, petty theft, and minor assault. The conflation of criminal and immigration law in this context has resulted in immigration consequences factoring into sentencing decisions for the court and plea considerations for the accused. This, of course, raises the question of the appropriate role of immigration consequences when considering sentencing. The Supreme Court of Canada has held that while immigration consequences are a consideration, they are only one consideration with the same weight as any other. And they have stated that such consequences should not have the effect of creating a separate sentencing scheme with a special range of sentencing options where there is risk of deportation. So, as you may have surmised, while conviction of a crime attracts doubly punishing immigration consequences, these consequences are seen as a necessary and inevitable result of committing even minor crimes in Canada, crimes for which a Canadian citizen would see little consequence. So the next facet of immigration that I'd like to discuss is the features of criminal law's enforcement apparatus that are also brought to bear in immigration. The statutory regime for deportation authorizes a detailed system of warrants and arrests, detention reviews, and physical restraints and isolation. BCCLA's work has been primarily focused on this facet of immigration, which concerns the expansive, unchecked law enforcement powers of CBSA. Most recently, BCCLA has been advocating for an end to immigration detention, beginning with the cessation of the contract between the province of BC and CBSA that allows CBSA to detain immigrants and refugee claimants in provincial jails. Contrary to international law, which holds that immigration detention should only be used as a last resort, CBSA routinely detains immigrants and refugee claimants in immigration holding centers and provincial jails with no timeline for release, and they maintain the ability to detain indefinitely. While in detention, detainees are regularly handcuffed, shackled, and held with little to no contact with the outside world in some of the country's most restrictive confinement conditions, including maximum security provincial jails and solitary confinement. Detainees have limited access to legal counsel and do not receive the benefit of any bail, hearing, or trial process. They routinely report having no idea why they had been detained in the first place. CBSA's detention regime also mirrors the racist and discriminatory practices and decision-making of our criminal justice system. For example, Black people are more likely to be detained in provincial jails and more likely to be detained for longer periods of time. CBSA also has a well-documented history of placing detainees with mental health conditions in solitary confinement and in provincial jails because of their mental health condition. CBSA officials have justified this discriminatory practice by stating that individuals with mental health conditions more effectively managed in jail, and they may have access to specialized care in these facilities. A 2018 audit commissioned by the chair of the Immigration and Refugee Board found that this was not the case, and those with psychosocial disabilities experienced a persistent lack of treatment and counseling services in provincial correctional institutions. CBSA has significant discretion when considering whether to detain. If an officer believes someone is visible and either a danger to the public or a flight risk or are lying about their identity, they may detain them. If, at the border, a CBSA officer suspects someone is inadmissible, questions their identity, or wants to conduct a further examination of that person's immigration status, they may detain them. The vast majority of people, 83%, are detained because a CBSA officer decided they were a flight risk. And in assessing flight risk, the officer is to consider the person's history of compliance with immigration criminal processes in Canada and the strength of their ties in Canada. This assessment disadvantages the many people who have no prior history with law enforcement and cannot demonstrate previous compliance. It is also unclear how ties in Canada are ultimately considered. Only a fraction of those detained, 1%, are held for being a danger to the public, and this number includes those who have already served a criminal sentence and have been deemed safe to return to their community. Detention reviews are scheduled for 48 hours post-detention, 7 days post-detention, and then every 30 days following. And these would ideally present a legitimate opportunity for continued detention to be proven by CBSA. In practice, this has not been the case. The same 2018 audit commissioned by the Immigration and Refugee Board chair found serious flaws in the detention review system. Not only do reviews not adhere to rules of evidence, decision makers tended to require the bare minimum from CBSA officers in order to prove continued detention. And officers routinely misstated facts and other critical aspects of files in their submissions. Reasons for continued detention were often unclear or missing from files entirely. The audit also revealed that CBSA is inconsistent with the application of policies and procedures across the country. Certain jurisdictions were found to be more likely to continue detention, and the audit uncovered a culture of delay in decision-making and processing that, in some cases, extended terms of detention by years. The federal government has recently introduced Bill C-20 to establish a new Public Complaints and Review Commission for RCMP and CBSA. This is not a solution. At minimum, the bill does not extend that oversight into provincial jails, despite CBSA itself previously noting its own inability to oversee and ensure human rights compliant conditions in non-CBSA facilities. So what is BCCLA doing about all of this? In February, we connected with Human Rights Watch and Amnesty International as part of their Welcome to Canada campaign to abolish immigration detention. They had made the strategic decision to target the provinces to end their agreements with CBSA, allowing CBSA to detain in provincial jails. The Ministry of Public Safety and Solicitor General agreed to review their contract with CBSA and accept submissions to aid in their review. Human Rights Watch and Amnesty were looking for assistance in mobilizing BC organizations to make submissions and rally around this issue. Since then, our work in this area has grown exponentially. We've brought together a group of passionate organizations and individual advocates, including those with lived experience of immigration detention, and we meet almost every week. We carried out a successful 14 Days of Action campaign, and just last week, we brought a motion before Vancouver City Council via our wonderful coalition member, Councillor Jean Swanson, asking for the city to call on the province to end its agreement with CBSA. This was a historic vote, the first of its kind in Canada, and the city voted unanimously in our favor. Resolutions were subsequently added to bring the motion before the Union of BC Municipalities and the Federation of Canadian Municipalities. We look forward to our continued work advancing the rights of immigrants and refugees in Canada. Thank you.
Thank you so much, Mara, and congratulations on that really significant win before City Council. Very exciting. Next up, I'd like to invite our Staff Counsel, Stephen Chin, to speak. Stephen joined the BCCLA team as an articling student in October 2020, and we are excited to have him continue working towards a more equitable world with us. Stephen will be speaking about the harmful and illegal practice of street checks.
Good evening. This part is divided into two sections. The first, a brief background and context on street checks, followed by second, challenging some long-standing assumptions to justify this practice. So first, some background. The BCCLA has long been advocating to ban unlawful and harmful street checks, and for good reason. But what do we mean when we talk about a street check? For many, carding comes to mind. Some say they are like police stops. For others, street checks are synonymous with racial profiling. A few examples can be helpful here. Consider a group of young men walking to school or playing a game of basketball and being stopped and asked to provide identifying info. This is from Ontario. Walking in the rain from BC, or walking your dog, also in BC, and not to make light of this, but as I tend to do, wandering aimlessly in BC. So the words that come to mind when we hear these real examples are random, arbitrary, and this is where Section 9 of the Charter comes in, which protects Canadians from arbitrary detention or imprisonment. The hard part is navigating what even the Supreme Court of Canada has called a murky line, a low visibility line that allows the street check to escape review, but marks the collision point where the police's duties to prevent crime and protect the community end and where our individual rights begin. The documented impacts and harms felt by communities subject to street checks can be severe. Street checks contribute to feelings of stress, fear, anxiety, trauma, and for some, feeling resigned to ongoing unfair treatment. They are a general and repeated surveillance tactic that erodes trust in public law enforcement. They can impact educational, employment, and social outcomes, leading to fewer opportunities. And most importantly, they underscore for the racialized communities who are disproportionately subject to high levels of interaction with the police, that these encounters can escalate and thus reverberate throughout the justice system and society. This self-reinforcing system of criminality, I quote, slams the door shut on upward mobility and upward equity in all aspects of life. So what does it mean to say that there is a disproportionate level of interaction with the police? For this, we have available stats, which both mask and reflect what racialized communities have been saying for decades. In 2018, the BCCLA and the Union of British Columbia Chiefs, Indian Chiefs, initiated a joint policy complaint in response to Freedom of Information obtained street check data from 2008 to 2017, demonstrating that Indigenous and Black people were disproportionately checked at rates 4 to 6.5 times their share of the general population. This has continued on in 2020 and 2021. So with this context in mind, I now turn to the second part, which is focusing and challenging a few assumptions that have been continuously used to justify and underpin existing street check policies. First, there is a common refrain across police departments that the authority to conduct a street check is grounded in the recognized police duties to preserve the peace, prevent crime, and protect life and property. Justice Tulloch of the Ontario Court of Appeal notes the critical distinction at law between, on one hand, a general police duty, and on the other hand, a specific police power. The difference is that police are not empowered to undertake any and all action, but have only limited and specific police powers to carry out their duties. In other words, they are not in perfect harmony. This is where the common law police powers come in, and where the legal concept that supports these powers, the ancillary powers doctrine, does not recognize a specific street check's authority. This conclusion is well-founded and inescapable. In our view, this closes this part of the debate. So police departments have also referred to one of Justice Tulloch's conclusions to support the idea that while police are generally free to ask questions of anyone on the street, regardless of whether an offense has been committed, however, the person being questioned does not have to answer and can proceed on their way. The Vancouver Police Department, for example, defines a street check in line with the provincial standards as any voluntary interaction between a police officer and a person that is more than a casual conversation and which impedes the person's movement. I'd like to pause to fully appreciate the insidiousness of this definition. It is inherently contradictory. It says that any interaction which is voluntary is one that, in the same definition, impedes a person's movement. Thus, we challenge the second assumption, in addition to the common law foundations of the street check power, which is voluntariness. As multiple commentators have noted, it defies reality to imagine a situation where a reasonable, racialized individual, aware of all the perceptions, experiences, history, and the imbalance of power between their community and the police, would feel like they, as Justice Tulloch says, do not have to answer and can proceed on their way. This feeling of compulsion within racialized communities to remain, answer, and comply with police questions, and to perceive these interactions as inherently involuntary, has not only been recognized by the Supreme Court of Canada and R.V. Lay, but through Lay now applies more fully to the line of cases that set out when a psychological detention arises. This recognition is also borne out in the research coming out of Nova Scotia. We know, however, that despite policies that continue to use this voluntariness justification, that an individual questioned as recently as July 2020 by the New Westminster Police was not informed at any point that his interaction with the police was a street check which he could voluntarily leave. So at this time, I return to the data. The most recently published VPD audit counted 14 individuals subject to a street check in 2021. The continued disproportionate impact on Indigenous individuals is stark. Half of them were Indigenous. Nearly half of the recorded street checks were classified as well-being checks. The 14 in 2021 represents an 84% drop from the 87 the year prior in 2020, which itself represents a 97% decrease from the 3,000 plus in 2019. This drastic year-over-year reduction has in part been explained by the new provincial standards, which I know were introduced in 2020. However, a recent survey conducted in Ontario reveals that even the enactment of regulation in that province has not significantly reduced rates of police contact. The numbers in BC support the idea that the street check has all but been eliminated within the formal collection of data. However, the elimination of a paper trail does not mean a corresponding elimination of racial profiling and how that manifests on the street. Thus, I leave you with a question. Were these interactions, numbering in the thousands just a few short years ago, even necessary in the first place? To conclude, we say that the response to disproportionate representation of Indigenous and racialized individuals in 6,000, 3,000, 87, or 14 street checks. The solution is not proportionate representation. The goal, in light of the law, the harms, and the history, has always been to ban this practice. The paper trail indicates that the foundation has shifted, but the lessons remain the same. We stress the need for more visibility. The data continues to be more and more obscure, but the experiences of our most vulnerable and marginalized communities show that more needs to be done. Finally, we stress the need to eliminate all forms of discriminatory street-level encounters with the police, including street checks and wellness checks. We'll continue to work with our partners to shed more light on this and other low visibility interactions. Thank you.
Thank you, Stephen, for sharing your expertise on this really critical issue. I will now be turning to our last panelist. So I'd now like to introduce the BCCLA's Policy Director, Megan McDermott, and she will be speaking on the issue of drug decriminalization.
Hi, everybody. My name is Megan, and it's lovely to be here and to talk about these important issues. I'll be talking to you about the harms of drug criminalization as we now have it, and what the BCCLA is doing to protect and advance the health, the dignity, and the human rights of people who use drugs. A lot of my talk is going to be informed by a civil society platform on drug decriminalization that we co-developed with other NGOs and advocacy groups across Canada. I'm very proud of this, and it really needs to be shared far and wide. And I'm very privileged to be talking to you about what's in it today. I can say that I think there were over 20 NGOs that were involved in developing this, and we've had over 100 groups sign on to it from across Canada. It involves drug users, health professionals, legal advocates, and friends and family of drug users and people who have been victims of the war on drugs. So it's my pleasure to tell you about it. You can find it on our website, but also at drugpolicy.ca. It's a really easy way to find it, and it's pretty short and accessible. So without further ado, here I go. Given the number of initiatives that are currently underway by all different levels of government in Canada, it's crucial for us to really interrogate what is happening and what we can do, what alternatives are available instead of what we know is a failed war on drugs. First, I'm going to outline how drugs are criminalized so that we all have a good understanding of what the status is. Then I'm going to name and explain the harmful effects of this legal approach. And then I'm going to talk about some of the initiatives that you might have heard of and how we're approaching them. So as we all know, a lot of substances are criminalized under Canadian law, and the laws that criminalize these substances are called the Controlled Drugs and Substances Act, sometimes referred to as CDSA as an acronym, and the Cannabis Act. For substances controlled under the CDSA, Controlled Drugs and Substances Act, the maximum penalty upon conviction for simple possession is 7 years in prison for a Schedule I substance. And this includes opioids such as opium, heroin, etc., as well as cocaine, coca derivatives, methamphetamines, etc. Then the maximum penalty upon conviction of simple possession of a Schedule II substance is 5 years. And these substances include synthetic cannabinoids, such as spice or K2. And then there's a 3 years in prison sentence for those convicted, that's the maximum, of a simple possession of a Schedule III drug. And these include psychedelics such as psilocybin and LSD, as well as mescaline, ayahuasca, and also stimulants such as Ritalin. The maximum penalty upon conviction for trafficking or possession for the use of for the purpose of trafficking is life in prison for Schedule I or II substance, 10 years in prison for Schedule III or V substance, and 3 years for one that's in Schedule IV. So it's pretty complicated, but hopefully you get the picture that people can lose their liberty for a lot of time just for simply possessing or using some of these substances. Under the Cannabis Act, we now know that cannabis is legalized in Canada. However, if you do break the law, you can face up to 5 years in prison. And illegal distribution of cannabis can result in somebody facing 14 years in prison at the most. So in addition to these formal criminal penalties, there are a host of informal consequences for drug-related activities that play a key role in further punishing people and adding to the stigma. So these involved barriers to one's access to housing, custody of your children, visitation rights, employment, access to health and social services. It also impacts people's ability to travel, their mobility, ability to move abroad, or even just travel abroad. Even if we decriminalize, as we think is needed, we would still need a huge push. Major efforts would be needed to combat the residual stigma and the discrimination that would continue based on the existing criminalization of the drugs. And we'd really have to pay attention and make sure that we're enforcing our human rights laws to really ensure that people are not being discriminated against for their previous convictions or previous drug use. Many families have been torn apart and many lives have been lost due to the state-sanctioned war on drugs. So I'm going to expand a bit further about what harms have actually happened. There's a growing body of evidence that criminalizing drug possession is ineffective in reducing the use and availability of drugs. It's a waste of public funds and it's taking a terrible toll on humans, on individuals and communities. It is an unjustifiable infringement on personal liberty and security of the person. Criminalizing drug possession puts people who use drugs at an increased risk of harm, including the risk of overdose. Criminalizing the use of drugs impedes people's access to health and social services and emergency care in the case of an overdose. It can also contribute to new infections of HIV and hepatitis. In Canada, criminalization has led to more potent and dangerous drugs. It's hampered efforts to scale up safe supply programs and contributed to a drug poisoning crisis that has resulted in almost 27,000 deaths between January 2016 and last September. This worked out last year to an average of 20 deaths per day in Canada. And based on the latest information that we have in BC, we are losing 6 people on average this year. Drug prohibition harms Indigenous, Black, and other racialized, marginalized, and low-income communities who are profiled and disproportionately arrested and incarcerated for the drug offenses. These communities are disproportionately subjected to child apprehension orders. And more broadly, criminalization perpetuates stigma, discrimination, and over-incarceration of these people and has been used to enact human rights violations towards entire communities. Okay, I'm going to move along now. There's a lot more harms that we can get into, but I will invite you to look at the platform online that I've told you about, because I need to get through to some of the initiatives that you might have heard about and how we're approaching them. So just recently, the BC government and the federal government made a really happy joint statement. They were very pleased to announce that the possession and use of drugs in BC would be decriminalized. So this, if you didn't know more about the issues involved, you might think that this is a good change and all that's needed. But I'm sorry to tell you that this is not happening nearly. It's going to happen too little, too late, basically. First of all, the exemption that's been negotiated for BC is not even going to kick in until the very end of January of next year. And that's if either governments don't rescind the agreement before then. So we're going to have at least another 7 months of people facing harm and people dying and families being torn apart. The other thing, again, is that it's an exemption. It's only going to be valid for 3 years, and governments can rescind this exemption at any time. And for those of us who have been around for a while, you may recall this is what happened with the safe consumption site here in Vancouver when there was a change of government. It went from liberal to conservative, I think, in the early noughts. And the safe consumption site actually had to fight to keep its ability to protect the community on the downtown east side of Vancouver. So the very same thing could happen with this exemption in BC. This move, we say, leaves people behind. Of course, it's a step in the right direction, but it's not nearly enough. And so I'll point out some of the shortcomings of it. For one thing is that it only applies to people over the age of 18. It does not apply to people possessing or using drugs in certain geographic areas, such as school properties, and then federal places such as airports and Coast Guard ships, actually. But even if you are an adult and you have drugs on you and you're just a passenger in a car being driven by a minor, the exemption won't apply to you. It only applies to some drugs. So it's only if you're in possession or using drugs such as opioids, MDMA, cocaine, and methamphetamine. Otherwise, it's the status quo. And this is a really key factor. The cumulative amount that it will apply to is that if you have 2.5 grams or less of a substance, then you won't be criminally liable. Now, given that the toxicity of the drug supply and that people are relying on the black market to get substances, one of the key issues here is about, will people even know what substances they have and at what point their volumes will trigger the criminal liability? As it is, we know that people are buying drugs to use and that it's not what they think it is. Now, this is also going to invite the police into having more interactions with people just to ascertain whether or not they're above or below this threshold of 2.5 grams. The drug use community, who have been largely frozen out of the negotiations between the province and the feds in this conversation, they were pushing for a much higher quantity. So this is going to discriminate against people that live in rural areas or who can't access where they buy drugs from, and they may stock up. So this approach will discriminate against somebody here in Vancouver would be able to get their daily supply and not face a criminal consequence. Whereas if you're living in a rural part of BC, you're still going to have to run the risk. If you go out once a month to get your supply, you're still going to face criminal liability. So again, we say this leaves people behind. What are we going to do? We're going to obviously be monitoring the system and hopefully make sure that if this exemption is all that we can expect from our governments for now, even though it's wholly inadequate, we're going to try our best to make sure that the police are adequately trained and that it doesn't result in more police interactions with the community, particularly communities that are already over-policed and underprotected. Hopefully, there's going to be a lot of data collected under this pilot project, and we would hope that the data would be gathered and analyzed by third parties rather than the police services themselves. I'm not sure if anybody's been attuned to the news today, but there's quite scandalous information coming out from the Toronto Police Services about the disproportionate use of force against Black, Indigenous, and Middle Eastern people in Toronto. And although it doesn't relate specifically to drug criminalization, a really disturbing part of this story is that that it was found that the police had misused data previously. And for anybody who's been involved in criminal justice and police accountability, you will know how important it is to get really good data, because that's the evidence about if discrimination is happening or not. And for the BCCLA, it was one of the starting points for us to filing a complaint against the Vancouver police about street checks, because there had been a question about whether or not police street checks in Vancouver were discriminatory or not. So although it doesn't seem that interesting, but actually really good data is really important to this conversation, because once we have unequivocal evidence that discrimination happens, even, communities say it, and that should be enough. But sadly, our governments don't take communities at face value. So instead, we need to have data ushered in, required by legislation, and then we can bring to light what's actually happening in terms of systemic discrimination in the criminal justice system. All right, I'm going to wrap that up now, and I look forward to the discussion.
Thank you so much, Megan, for, wow, just all of your expertise on this really important and timely issue. I'm now going to turn to some questions for our panelists. And my first question is for Megan and Stephen. So as many of you joining us know, British Columbia will be decriminalizing the possession of 2.5 grams of many different drugs as of January 31st, 2023, as Megan just spoke about. Megan and Stephen, how do you feel that the intersection of illegal practices such as street checks will be impacted by decriminalization? Does the threshold for decriminalization put people who use drugs in danger?
Thank you for unmuting me, to the team who's supporting us all behind the scenes here. Yes, thanks for that question. Definitely, it's going to put people in danger. As I was just outlining, it's really hard to know for a user, and of course for the police, to know what a substance is. And how much, if there's something in a baggie or a little packet, are you going to assume that all of that is the active ingredient or not, right? Like by the time that you get it to a lab and test it, the substances that might be controlled under our criminal laws might not even be in there, or it could be in there at a much lower level than either the user or the police officer suspects. So we have really a lot of questions around how this is actually going to be enforced. And as a lot of people have been saying in social media, is this the de facto legalization of street checks, which, now that governments have finally been trying to come and restrict the voluntary interactions between police and the public. Now are we going to see this regressive any progress that's been made, it might be undone by virtue of this exemption. So again, there are a lot of questions, and we're also concerned because it seems that the exemption is going to add to policing budgets, because police are going to be, they're going to still be very, very much involved in policing how people use drugs, and whether or not they exceed that threshold limit. Another thing that I failed to mention was that this exemption, we think, will still allow police to confiscate the drugs. And how is that going to be productive for anybody? We know already in BC where often police will charge people with drugs, or attempt to charge them, but then the charges aren't approved, so the person never has to go to court for it. We know that that the substances are confiscated time and time again. So again, the key issue about people using substances, like we're not really talking about the root issues at all. And so it's gonna end up with potentially a lot more harm being levied on communities. And obviously, just even having the police have to think about that threshold issue, right? I think it's going to invite police into a lot of voluntary interactions with people on the street, people who don't have housing and people who can't consume substances with dignity in the privacy of their own home, and they'll be left, they can be observed. And I think, you know, it's just going to invite further criminalization of these folks, even if their drugs, even if they don't face a criminal conviction and a loss of liberty for it. Again, they're going to lose the drug that they want to use, their property. And then also their information is most likely going to end up in a police database. And then you end up with all those other risks of harm by virtue of this civilian screening issue, which happens in terms of like child custody issues, employment, and just even being known to police or known to have associates who are known to police can really inhibit your ability to live life free of discrimination in our world, because we're starting to see more and more police checks and civilian screening type things happen. So I'll end my comments there and invite Stephen to add anything.
Yeah, I think I summarized it very well. I have two small points. I would say first, the vicarious or the knock-on effects to for example, passengers, as Megan mentioned in her remarks, as well as colleagues or friends or other people that may be impacted by the check. Those have to be considered as well. And the second relates to timing. As Megan said, the decriminalization will come into effect in 2023, and at that time, I think the data collection will have to be there, and that'll be conducted through, I think, surveys by third parties, as well as to ensure that it's independent. So those are the 2 points that I wanted to make.
Thank you both. I'll now turn to my second question. So continuing on the topic of street checks, I'd like to ask our panelist, Mara, about how street checks may impact those who are already experiencing the effects of crimmigration. What intersections may come into play, and what is being done to resist the further criminalization of immigrants and refugees?
Thank you for that question, Jess. It's a really good one. So one of the main things that come to mind is that street checks tend to pull people into the criminal justice system via a really gray area, much like the intersection between criminal and immigration law. So it's unclear what rights even Canadian citizens have in the context of a street check, or how they would go about meaningfully exercising or enforcing those rights. Now imagine that same context, but a foreign national or a permanent resident whose rights have already been deemed lesser than a Canadian citizen in the eyes of Canadian law. Because street checks deliberately target oppressed and marginalized groups, including Black and Indigenous people, it's reasonable to assume that foreign nationals and permanent residents from these racialized and other groups are more vulnerable to being street checked in the first place. And then knowing that offenses of petty theft or simple possession, or I didn't discuss before, but in the context of organized criminality, even CBSA's reasonable grounds to believe that someone is affiliated with organized crime can carry immigration consequences, such as the indefinite detention I spoke about, or deportation. So with all that in mind, it means the result or the consequence of street checks are exponentially high for an immigrant or refugee claimant. It's also important to note that it would be difficult, if not impossible, for someone from that population to pursue a complaint about an unlawful street check if their immigration status had lapsed, for example, or they had other concerns in that regard, out of fear for coming to CBSA's attention. So that stifles any rights they might have of exercising due to the fear that these crimmigration consequences attach. So really, ultimately, street checks are an unauthorized avenue for foreign nationals and permanent residents to come to the attention of the police and CBSA with potentially devastating consequences, as we know, that are even more severe than those faced by Canadian citizens. But by working to expose these systems, to bring them to light in terms of the immigration detention system, the intersection of criminal and immigration law, as well as lifting the veil on street checks and talking about them, BCCLA is doing what it can to dismantle what is essentially invisible exercises of oppression that immigrants and refugee claimants face every single day. And we're going to continue to do that.
Thank you so much for that, Mara. I'm now going to turn to our third question. Sorry, I just had lost my place for a moment. Given how the criminalization of both people who use drugs and immigrants reinforces illegal practices such as street checks, Megan, would you be able to speak to how criminalization affects the civil liberties of the broader public?
Yeah, sure. This is a very wide-ranging question. And so I guess the way that I would approach this is to say that, you know, this oftentimes a criminal law, when it's used, there's an assumption by a lot of people that that the state is really going after, you know, dangers to the public and people who are ultimately really compromising public safety and putting all of us at risk. In the work that we do, it becomes very clear very quickly how wide the net can be cast. And that even if the state is starting with, you know, a very kind of narrow approach or something that seems legitimate, if you were to hear it on the 6 o'clock news, that once you start to scrutinize it and see how it's being used, there's a whole lot of scope creep. And so, you know, what I would suggest to people in the audience who may not have family members or friends who have been involved in the criminal justice system, I would just suggest that we're all very close to criminality at any moment. Of course, depending on our identities and how we conduct ourselves, can be more or less at risk. I'm pretty sure, so, you know, I'm a white middle-class woman, and I do know that there's one area where white middle-class women are overrepresented in police interactions. And this shouldn't come as a surprise to people because I've benefited from it myself. And it was from actually a report into the street checks in Nova Scotia. And the one area where people like me are overrepresented is getting off without speeding tickets. So, and this is where data can be really, really great. So, you know, while people like me can be getting off there, I at the same time know by virtue of my own connections with people in community, and now even with there's federal initiatives looking at regulating social media providers. And we saw a bill last year before the election, and we expect another bill to come soon. And this could really put a lot of us in the crosshairs of criminalization of the state. Even how we communicate with each other on social media, if we're using Facebook at all to arrange protests. If we went to support land defenders and stand in solidarity with them against pipelines, we could very easily end up in a police database if we aren't there already, and have information about us and our associates shared with even secret security agencies. And very easily, that kind of information can even end up in the hands of foreign foreign states that we collude with as well. So this is all just to say, I just hope that we're not too comfortable, those of us who don't feel the full force of the state, because for those who do, and they do, the evidence more and more now that our state is pretending to care and starting to look at evidence, you know, as I mentioned before, the police story, which is just so disturbing out of Toronto today. And Toronto's, that's the oldest police force in North America. And I guarantee if it's happening there, it's happening here, I guarantee. And that this is, while it's a systemic issue, it's upheld by individuals. So we just need to stay, we're gonna stay militant about it. I also wanted to quote some people, some very inspiring people. This is particularly around drug use, but Elle Jones is a wonderful activist, author, and professor working out of Nova Scotia, and I recommend people check her out if you haven't come across her already. But this is a quote that I wanted to leave you with. The stigma of drug use ruins lives. It is long past time to stop funding a war on drugs and to invest in real public safety, housing, mental health, childcare, and living in a society free of oppression for all people. And I think I'll wrap up my comments there.
Thank you, Megan, for those insights and that powerful quote. And thank you all for speaking on how our collective freedoms and liberation and rights are intertwined. So I'd now like to open the floor to questions from the public. And if you have any questions from our panelists, feel free to put them in the chat in the Zoom room or on the YouTube live stream chat. And I see that we already do have one question from a member of the public. So here it is. What should the BC government have negotiated regarding drug exemptions rather than the 2.5 gram exemption that will take effect in 2023? What would have been a better position to negotiate for? Yeah, and I think that might be best directed to you, Megan.
All right. Well, one thing I'll point out is that Dr. Bonnie Henry, a few years ago now, I think it was in 2018 or 2019, but she recommended to the government to decriminalize drugs using its health powers. So there are some people, including the medical officer of health in BC, that think that the province doesn't necessarily have to wait for an exemption from the feds. Okay, so that's one perspective. Another one about the negotiation itself and the exemption is that the drug using community that I'm aware of that was pushing to be represented at these tables, first of all, they were frozen out of it over and over again. So what's so sad about this is, you know, as with a lot of areas of law, targeting different populations, people say nothing about us without us. And in this case, the drug using community itself is being regulated and being left behind, even though police are consistently invited to the table. And so the drug use community that we're aware of and that we work in solidarity with, they were asking for a threshold of 4 grams. So, you know, 2.5 grams falls significantly short of 4. So that's just, you know, an additional idea about what was needed. And probably it would be needed now rather than 7 months from now. And like I say, Dr. Bonnie Henry pointed that out years ago. And at the time, a whole bunch of us sent letters to the Minister of Health asking what was being done. So everything that's being done is too little, too late. But at the same time, it's obviously welcome to see these changes. However, there have been other jurisdictions who have applied now for exemptions. I know that Toronto has. I don't know if another province has, though. But the idea now is that that the precedent has been set, right? So with arriving at this compromise, or this political compromise with police, I'm not even too sure why police would have a say in what the amount should be, but for it to now be at 2.5, probably we're going to see that replicated with all the other exemptions, and it's, you know, just going to continue to have devastating consequences, because the people who actually use drugs are going to continue to be criminalized.
Thank you, Megan. The next question I have, maybe I'll direct it to Mara, and it's about the role of different levels of government in addressing these systems of criminalization and their disproportionate impacts on marginalized people. So the criminal law, that's a federal power, and yet in the remarks you've all shared this evening, it's become clear that other levels of government do have a role to play in addressing these systems of criminalization, whether it be through, you know, your lobbying at city council, or BC negotiating a deal with the feds with respect to decriminalization. So what do you think, what place do you think there is for other levels of government in addressing these criminal law issues?
Thank you for the question. Well, I think the idea, the maybe misconception, is that lower levels of government, so-called lower levels of government, have very little power in a lot of these circumstances. And what we're learning, and what we really experienced last week at City Hall, that actually the municipal level of government has a huge amount of influence in a huge amount of just autonomy and decision making that they don't always want to exercise, and that it is worth engaging with them on a lot of these issues. So, for example, when we started out with the motion before Vancouver City Council, I don't even think we're thinking about the possibility of bringing it to the Union of BC Municipalities or the Federation of Canadian Municipalities, and that collectively those organizations carry a lot of weight and a lot of political power that can be used, if nothing else, than for making the issue well known and shedding light on it, which is really important. One of the things I also want to talk about in the context of immigration, for example, and crimmigration, is Vancouver's own access to city services without fear policy, which is something that we really spoke a lot about with City Council in the lead up to the vote, which is a policy that was passed by City Council that allows for people whose immigration status has lapsed or who have concerns about their immigration status to access city services without concern that the city official on the other side will report their status or disclose information about it to CBSA. And they have no duty to do that, for example. And a lot of people would think that maybe they do, that maybe all of these levels of government are connected and working in concert to oppress people. And in many areas of our work, we perhaps do see that. But in this area, the city of Vancouver is doing its part to protect people and the people who make Vancouver what it is, by protecting their immigration status from another level of government. And we also have seen in the drug policy realm a lot of moves from BC that we hope will influence the rest of the country. So in that realm, it's really important. And we talk a lot about that with other drug user groups and other advocacy groups in the drug policy realm, that BC needs to realize its role and its place in this conversation, that it is a leader, that it is at the forefront of these policy changes. And we hope that the federal government will feel that weight and be propelled to move in that area as well. But I think the bottom line is to just not underestimate the role and the creative ways you can involve your municipality, or you can involve your province in advocating for things even at a higher level of government.
Sorry, thought I was unmuted. Thank you, Mara. Another question from the audience. I am an immigrant. If I ever get street checked, what should I do to protect myself? So I think Mara might be best positioned to answer this one, but if someone else prefers to take it, please go for it.
Yeah, thank you for sharing that. And of course, it's a really difficult question to answer because, as I said, out of even Canadian citizens are unsure of their rights in the context of street checks. But what we would invite you to do is definitely to reach out to us here at BCCLA, to look us up, to contact us, and we can do our part to connect you with other organizations that we work with to address these issues. But definitely don't be silent on it, and don't assume that you have no rights in that context, because you do. And we're here to help you work through that. And we have a role to play in the community and in helping individual people with things that come up in their daily life when they're interacting with these systems. So for sure, reach out to BCCLA and we can talk about making a complaint, and we can talk about putting you in touch with other organizations as well.
Thanks, Mara. Another question from the public. Do you know if there are quotas for the police force for the number of offenses they have to find and deal with? So if police have certain quotas for, I guess, like how many people they have to charge?
That is an excellent question. And I don't know. The only kind of twig in my memory around quotas is that I do know that when carding was under scrutiny by the Toronto Police Services, that it was found that they had to reach a quota. And the reason that it's called carding in the Toronto context is that the police would actually leave you with a card, kind of like a business card, like, by the way, we messed with your rights and this is who we are. But that's why we have the word carding. And that's no longer a practice that occurs. It's now been restricted under an Ontario law, but there is an ability under the law for police to do checks in Ontario, even though it's no longer called carding. But that's the only case that comes to mind for me. Now there may be quotas and we're just unaware. Something that's really interesting and also disturbing and surprising is that a lot of how policing and law enforcement agencies operate is actually quite opaque. It's really, really difficult. I would invite you to even look at your local police agency, be it the RCMP, or even if you're in New Westminster or whatever jurisdiction you fall under, try to find out if they have policies on street checks, or even what their arrest policies are, or if they have any information about how many arrests they've conducted and for what offenses. It's all very, very not to say like secretive, but it's just their impulse is not to be forthcoming. And one that really stands out as one of the worst for this is the Canadian Border Services Agency. They won't even proactively share policies or guidelines with people. And I mean, this is really problematic because a big tenet of the rule of law and about how democratic societies work is that the citizens have to know, or should always know, when they're rubbing up against the law, right? Part of being legal is knowing what is legal, right? So if you don't have notice about something being wrong, then it's very difficult to hold people accountable for that. So yeah. This is all just to say that I would invite you as a person to maybe try to see how forthcoming the police are. But you know what? I also invite everybody to just ask if there are quotas. I don't think that you're going to get an answer. And again, it's something that we might kind of find out after a scandal occurs. And if there's been like a commission of inquiry or something like that. Again, as with the issue with carding, we found out about quotas because it became a political scandal. So no, they're just not forthcoming, but there might be quotas and we're just unaware. There shouldn't be. I mean, that would be arbitrary and disgusting. But if anybody knows about quotas, feel free. Bring them to our attention.
Thanks, Megan. I have another question from the audience. This one for Mara. One of the few rights under the Charter that migrants don't have is the right to vote. They are politically ignored in part because they aren't a political constituency. Can this change, and should this change, and how?
Well, I would say that it should change. How could be via a charter challenge or a large legal challenge to this kind of issue. One thing that's really interesting, I think, about the role that immigrants, for example, play in the Canadian context is that Canada really likes to be proud of its work in terms of inviting people to Canada, and is really proud of its quotas, speaking of quotas, of immigrants and refugees that come to Canada year over year. But in a lot of cases, it's in the economic stream more and more about the pride that Canada takes in its immigrants that come and bolster Canada's economy. The number is huge and growing year over year, and Canada is all happy to welcome people in that stream into the country and then not meet them with any kind of rights as critical members of Canadian society. Just in that alone, I think that there's a massive incongruency there in the idea that there's no political weight or power behind the immigrant population, where Canada literally relies on the immigrant population to make its number one priority, the economy, grow. And that is something to think about when thinking about all of these things, and something we'll be keeping in mind in all of our advocacy, in that it's really not the case that immigrants have no political power. It's just Canada's willingness to ignore that power. And maybe it's our job and the people that we work with, the organizations that we work with, to bring that to Canada's attention and do what we can and put our efforts and energy behind challenging Canada on that, both just in terms of policy, but also perhaps legally down the road.
Thank you, Mara. Such a good way of putting it. It's not that immigrants don't have political power, but it's Canada's willingness to ignore that power. We have one last question from the audience. I guess this could either go to Stephen or Megan. The question is VPD really doing fewer street checks? Or are they just, which is what they were reporting, or are they just not documenting them? Do we know?
Yeah, I think, as I said in my remarks, there's the possibility, of course, that it's simply the paper trail that is reflecting a drastic, as I said, reduction in the amount of street checks that are recorded. In my view, street checks are part and parcel, part of the category of low visibility police interactions, and whether or not that recording of a street check thus translates into recording of every other low visibility police interaction, that's a question that has to be, I think, explored a little bit further. And the question still remains whether or not the recording of street checks on paper has either shifted or completely shifted somewhere else or has completely been all but eliminated. So I think, as I said, part of it has to do with the collection of data, and it could be that the third-party piece is what's missing here. A lot of the data that we have is from the VPD, but it also means that we need to conduct a little bit more of community surveys and get a more, I think, wholesome picture of what is actually happening on the street. So that's what I would say to that question. I don't know if Megan wants to add anything else.
I don't have anything to add, except to say that I would also be concerned about characterizing them differently in the database. As we saw with a lot of the agencies trying to make policies to comply with the BC standards, there seemed to be kind of a lack of understanding about even how to characterize these kind of interactions. And now, even when I say an interaction, that implies that the person will have interacted with the police, but when the VPD did, when they commissioned a third-party report into their street checks and their practices, a lot of them that were being, a lot of them that ended up being scrutinized didn't even involve an interaction. So it would be police officers just watching, say, from their car, and you wouldn't even know, but say that they knew who you were and they were watching you go into somebody's house or just hang out with somebody on a bench. That would end up being captured into the database, and so the person wouldn't even have known that they were under surveillance by the police and that the information was being collected. And one of the things that we've been also trying to get at in this conversation around street checks is that issue around privacy rights and just about collecting the information about people in the people that they're with and associating with. Again, it's kind of where the oversight mechanisms for a lot of the law enforcement bodies fall short, because we have different complaint, like say we have an office of the police complaints commissioner, and then we have like this privacy commissioner over here, and they work at cross purposes, and there's not an overarching civilian-led agency, which is something that we really need. So yeah, I think that we're still trying to unravel actually what's happening with the data around street checks. And of course, I want to point this out because it was a disingenuous thing that the cops did at first. They said that there was this drastic drop, but it was around when the pandemic had first hit everybody, and basically people weren't walking around. And the police, the chief of police was even like bragging about the numbers dropping and not mentioning the pandemic. So, you know, it's from experiencing stuff like that that we are a bit skeptical. And so we'll continue to monitor and try our best to dig into the numbers.
Thanks, Stephen and Megan. And so that is our last question for the evening, and that includes the open portion of our panel discussion. But before I wrap up this panel, I'd like to say a big thank you to our panelists, as well as to the staff in our engagement department working very hard this evening behind the scenes to put on this event. So these are our communication, outreach, and fundraising folks who work day in and day out, connecting with supporters and amplifying the work we do out in the world. And very big thanks to you folks. So that is Zoe, Amy, Greta, and Owen. I'd also like to mention that we're excited to be announcing an event on privacy rights coming up very soon. So you should follow us on Twitter, Facebook, and sign up for our email list at bccla.org to stay informed on our programming and on the work we're doing. And thank you to everyone who has joined us this evening. We hope that you have found it informative and empowering, and we just would like to wish you a great evening. Take care, everyone.